I don't know if you know this, but the NAR has actually trademarked the term realtor.
Yeah, I saw that. Growing up, I always just thought that was the name for everybody who bought or sold houses. I didn't realize that was like this technical term.
I know. So not only price fixing, but they also co-opted the term. The term realtor.
I mean, let's see if we get sued for it, but they've got a bit of a stranglehold on the industry.
They really do. They really do.
Ever wonder what really happens when your rights are violated and what you can do about it? Ever wonder what the law looks like outside of TV dramas and headlines? Meet Quinn Mayberry, a Harvard-trained trial lawyer who has helped individuals recover millions of dollars, and Alex Lobert, Quinn's lifelong friend and your law translator-in-chief, here to make the law make sense. On this show, they cover headline-making legal battles and overlook cases to show you how to fight back and win. This is Legally Curious.
All right, Quinn, picture this. Rhonda Burnett sells her house for $250,000. At closing, she pays over $15,000 in commissions. Now, half goes to her agent, which personally I think makes sense, but the other half goes to the buyer's agent. That same buyer's agent that actually negotiated against Rhonda to try to lower the sale price of her house. Now, if that sounds a little funny, Rhonda thought so too. Here's what she said at trial. I paid the buyer's broker to negotiate against me and my husband.
Tough pill to swallow. Today we're talking about Burnett versus the National Association of Realtors. This was the largest antitrust verdict in real estate history. $1.8 billion automatically tripled through something known as treble damages to $5.4 billion. What did this federal jury find NAR and other major brokerages guilty of? Conspiracy to fix prices.
All right. Now, how did the biggest real estate organization in America, with over 1.5 million members, get away with price fixing for decades? And what does that mean if you're buying or selling a house right now?
Yeah, let's find out.
So, Quinn, I want to say something. You said realtors very well in the intro there.
Thank
I don't
you.
know if you know this, but the NAR has actually trademarked the term realtor.
Yeah, I saw that. Kind of crazy. Growing up, I always just thought that was the name for everybody who bought or sold houses. I didn't realize that was like this technical term.
I know. So not only price fixing, but they also co-opted the term. The term realtor.
I mean, let's see if we get sued for it, but they've got a bit of a stranglehold on the industry.
They really do. They really do. So I don't know. Do we want to get into the conspiracy and talking about like how this actually happened?
So what's happening here? If you want to sell your house, you reach out to a broker. You reach out to an agent who's going to list your house and help you sell it. They might help you market it. They'll help you with the paperwork, so on and so forth. They help you sell your house. They also list it places where buyers are more likely to see that listing. This is kind of at the core of everything that's going on. These marketplaces are controlled by agency organizations. And one of those big organizations is the National Association of Realtors, the named defendant in this case. So they have this listing service where you reach out to a seller's agent, your seller's agent puts your house on this listing service, and then potential buyers see it. So part of what's listed on that listing for your house in the past was the commission the buyer's agent was going to make. So before buyer's agents chose to show houses to their clients, they would see the commission they were going to make. So if they were going to make 0%, what are the odds they show it? It became this industry practice known as steering, where they would steer their clients, the buyer's agent would steer their clients towards homes where they were likely to make a higher commission. And to be clear, that commission was being paid for by the person selling the house. Why would they ever pay that amount? It's so the buyer's agent is more likely to show their house and thereby their house gets sold. Is that making sense? Did I miss anything?
So what's amazing about that is it makes perfect sense for the real estate agents. Right? Right. I mean, 100%. It's like, I am joking here. By the way, I love my real estate agent. He is wonderful. But, by that logic, it's like those times when your real estate agent can't make it to a showing, it's like, oh, that one might not be where they're making any money, right?
Yeah, like, commission's awfully low on that one, huh?
Yeah, or maybe even you show and you're like, you know what? This, look at shoddy workmanship. Like,
yeah, there are tons of great buyer's agents who are just looking out for their client's best interest. But then you'll read these articles where there's a culture of people getting hazed for selling a house where they make 0% commission. And you're like, well, if that's how the industry is structured, who does this serve? I guess is ultimately the question.
Well, exactly. And because I totally agree with you. Poking fun aside, I think there are a ton of great agents, but the system drives towards the practice of steering. And yes, you can be caught up in the system, and to buck the system, as you just talked about, actually is like, it's not easy. It's not easy to do that.
100%.
And the other part of it is, I think that a buyer generally wants their agent to get paid. So that isn't even the buyer's objective in that transaction either, right? Having them get 0% commission, and hopefully in that context, they were able to negotiate to get something. But like that actually, nobody wanted that.
Yeah, I mean, look, plaintiff's attorneys, the attorney in this case works off a contingency fee, makes a portion of the case. What you don't see happening is the plaintiff's attorney isn't representing the other side of the transaction, or the plaintiffs aren't paying their own attorney and the defense attorney. And so you start getting into this conflict of interest where there's this fundamental tension between the principal who's deciding who their agent is and the principal that's paying for that agent have become disentangled.
Yeah, exactly.
And there's no negotiation. And so it just leads to this tough situation where prices have basically stayed at 6% and we get to these allegations of price fixing.
All right, let's quickly refresh on the plaintiffs in this case. So Rhonda Burnett, she was a former school psychologist and she was selling her home with Home Services of America. And she actually got a listing agreement. So when she was trying to sell her house, and it already had 6% filled in terms of the agent cost that would come with selling her home. So as I mentioned earlier, she sold the house for $250,000 and the commission was $15,298. And again, as we were noting, that part of that went to her agent, but also part of it went to the buyer's agent. Rhonda's case is emblematic of this problem that we've just been discussing. And because of that, we get a lawsuit. Quinn, do you want to talk about the causes of action for this case? Why was what the NAR did illegal?
Yeah, absolutely. So the core cause of action was this violation of the Sherman Antitrust Act, which is 15 USC Section 1. And they violated that act by engaging in a price-fixing conspiracy. Specifically, the plaintiffs claimed that the NAR and the defendant brokerages knowingly and voluntarily engaged in a conspiracy to raise, inflate, or stabilize broker commission rates paid by home sellers. The core anti-competitive practice challenged was NAR's rule requiring home sellers to make a blanket offer of compensation to any potential buyer's broker as a condition of being listed on this multiple listing service. And this is known as the cooperative compensation rule or buyer broker commission rule.
Quinn, so if I got this correct, if you didn't actually pay the buyer's commission, you wouldn't get listed on the MLS and you likely wouldn't sell your house.
So basically, the one little wrinkle is you very well could be listed, but the buyer would see this big 0% commission next to the listing. There'd be nothing private or secretive about that. Right up front, they would see this 0% commission. And what's the incentive to sell that home to a buyer whenever, by the way, there's a lot of commissions that say 3% right next to it.
You know what's really funny? Being a marketing person, you could make your house beautiful. You could do all the right things. And then literally, if you don't pay the buyer's agent, you wouldn't get the buyers to come through the door. It's like the worst advertising ever, right? Like, oh, and the person showing you the houses will make $0. Okay, so it looks like they are price fixing and forcing sellers to actually pay the buyer's commission. That is the NAR in their policies. But how did they prove it? Like, how do you actually show that this is happening and it's causing harm?
Great question. So there are some internal NAR documents that revealed communications about maintaining commission structures and resisting changes that would introduce price competition. We've got our old friend internal documents.
I am always amazed how many companies break the law and then write it down. It's kind of amazing.
You and me both. And I'm like, surely that's not written somewhere. But then whenever you think about the scale of these companies, it's really hard to get people aligned and get some efficient cooperation around these objectives without having this stuff, communicated anywhere internally.
That completely agree with that. That makes perfect sense. And I bet you, and I don't think it matters. Actually, I'd love your legal opinion here. I bet you that most of the people didn't even realize this was illegal.
I think that that's probably exactly right. Arguably, it wasn't considered illegal for a long time. I mean, we haven't even touched on the tens of millions of dollars in lobbying fees. People aren't going to love to hear that one, but NAR was spending more on lobbying than Amazon.
That's how you know you're on the right side of the issue.
Yeah, exactly. It's like, we're so sure that if we spend about $70 million on this, people might agree.
Yeah, right. Or at least they won't know what's happening.
Yeah, we'll make it murky enough. Yeah.
Right. But beyond the internal documents, I thought it was really interesting that the Burnett and her lawyers actually brought up experts that were able to prove, or at least provide very compelling evidence that there was price fixing, right?
Yeah, that's exactly right. So we'll see economists in a lot of these cases, especially whenever it's related to something more technical. And we want to understand what these trends, one, what the trends in the industry are, and two, what they mean. Like, why might that be happening? So Craig Schulman, who's an economics professor at Texas A&M, testified for the plaintiffs, basically said NAR's competitive compensation rule was one of the clearest cases of price fixing and collusion he'd ever seen. I mean, and so I guess I pause. I
know if that isn't damning testimony enough.
Yeah. Powerful one-liner there. And then Schulman's analysis showed that the average buyer commission rate was 3% in 95% of Missouri home sales studied.
Right. So that fundamentally means there was no choice. What, everyone just picked 3%? Right?
Yeah, it certainly starts looking fishy. I'll give myself a little out with legalese. But yeah, it's like 95% were landing on this commission rate of 3%. starts raising some questions about whether or not this was actually negotiated or if the market had any room to create pricing here.
Bringing in an expert like this, I found it really interesting. I feel like you hear about experts often in cases that involve like medicine. It's like, oh, I needed a doctor to come prove that this person was injured. I thought it was really interesting, like bringing in an economist. The different types of experts in legal cases are really interesting to me as a non-lawyer.
Yeah, I find them really interesting. I think it's actually a really fun part of the practice. You become, an armchair expert of sorts on all of these different industries. And you get this phenomena oftentimes to be slightly more cynical about it, where you have these dueling experts, where plaintiff's expert's going to say one thing that's beneficial to the plaintiffs, defense expert's going to say one thing that's beneficial to the defendants. And I think that oftentimes the jury, understands credibility and can kind of suss out what's BS and what's not. But you'll see facts and figures becoming really important in cases like this. The defense is going to put up somebody who says maybe the exact opposite thing, but where it's really hard to get just diametrically opposed opinions is, well, in 95% of the transactions, was the commission rate 3%? It's like really hard to kind of dispute that.
Exactly. Whenever you have the right data, and that's where experts are very important, it makes it really hard to argue with.
That's right. At least credibly argue with. Because
credibly argue, fair. It makes it hard to credibly argue it.
I've seen people try. They will bend numbers, but yeah, you lose credibility. That's what the jury's there for.
So what's the verdict? What's the outcome? They're accused of violating the Sherman Act, basically engaging in price fixing. They have internal documents proving that they told people functionally to collude. There are experts saying this is one of the clearest examples of price fixing they've ever seen.
And maybe one more thing real quick. There's this laundry list of arguments they make, but they also drew a comparison to international markets, and they showed that U.S. commission rates were maybe as much as 2 to 3 times higher than comparable countries with competitive agent markets.
Well, sounds like
you start to wonder, maybe this one's not competitive.
Right. You maybe think this isn't really a market. So what actually happens?
$1.8 billion with a B billion dollars.
It's a big number.
Really big number. And that's before it was tripled to $5.4 billion.
Which is wild. And you mentioned this in the top, Quinn. There was a unique reason it tripled, right?
Yeah. So there's this concept known as treble damages, which fancy way of saying, you're going to triple the verdict. And the idea there is you're trying to aggressively discourage people from this type of behavior. If you do it, you're going to be responsible for whatever the damages are considered to be, in this case, $1.8 billion. But then we're going to triple it as this disincentive to engage in that type of behavior. We really don't want to see it happen. It's kind of hard to enforce. So we're going to have this big disincentive of whatever your damages were, triple it.
So obviously the NAR wasn't really happy about this. They were saying that what they did was equitable and, transparent, even though obviously having to pay, over $5 billion is a bit of a hit to that argument, in my opinion. And they also had some new rules, right? So the NAR actually now has to not display commissions on the MLS.
That's right.
And there is not a requirement to offer buyer commission associated with a sale.
Although to be fair, I'm not sure if that's a new rule. That was part of the settlement, but I don't know if they were ever technically required to.
Okay, that's fair. That's fair.
Yeah.
All right, let me take it from the top again.
No, but that was listed in the settlement as like one of the big points, and there's just a lot of conversation around like, did that actually even change anything? Because that was chalked up as like a bit of a win, but
fair. Maybe it's more like it's codified in law that you can't do it.
Yeah.
Right.
Or that they don't have to. Yeah.
They don't have to do it. So the NAR obviously said what they did wasn't an issue. Kind of a hard thing to argue when you're paying $5 billion for your practices, but oh well, you might as well argue it. But they also, beyond paying the money, they had some new rules they had to at least legally comply with. One, they could not show a commission on the MLS. So no more, big red zero. I don't know if it was red, but big zero next to your listing if you weren't paying the buyer's commission. You actually can't be required to pay the buyer's commission. I know, Quinn, you and I were talking about this. Unclear whether that's really a meaningful change, but it's at least part of the settlement, right? That they can't do it.
Yeah.
I
was just gonna say, really quick note there. Some of these things were just, they formalized practices that were already supposed to be the standard, but they just made these things explicit. That's
exactly. And so they made it mandatory to have buyer agreements before home tours. It's kind of interesting. And there needs to be written disclosure of compensation.
Yeah. So more discussions about who's paying for what. They make it more explicit. They make it more explicit that those rates are negotiable. And I think the single biggest change is that you're not going to see that big fat zero that you mentioned on the MLS. Now, do we move on to
what's actually changed? Yeah, let's do it.
So a lot of industry experts have been keeping up with this and asking, what has this actually changed in the industry? We saw a temporary dip in buyers' commissions, a small, like a very modest dip of, a couple basis points basically, that maybe has even since rebounded. And the question is, why wasn't there a bigger change? Or at least that was a question for me. The answer is basically that single biggest change, that the buyer's agent would no longer be seeing that their commission rate on the MLS, didn't have a whole lot of effect because they're just getting the commission rates through other means of communication. They'll pick up the phone and they'll call and ask, what's the commission on this house? They'll even just start group chats where they're communicating about it. And so I think, you and I were talking about the impact, what this actually changed. Kind of hard to say, but I think we probably agree on this. This stuff doesn't change overnight. And it seems like this was maybe a step in the direction of disentangling, or better yet, of kind of re-entangling the incentives, where there are conversations about who's paying who and how much are they paying. And then look, the agents are providing a lot of value in these transactions and should be getting paid. It's just about the lack of transparency in this misunderstanding about where the money's coming from and who's paying who. And so I don't know. I'm of two minds on this one. I think that they ultimately settled that 5.4 billion for, I think, $418 million. Big chunk of money. But the biggest changes from this are going to be the structural changes to the industry. It's too early to tell exactly how those are going to shake out. I think that it opens up space to make changes, and it also shed a lot of light on the industry.
Similar takeaway. It makes people more aware of what's happening. And I think that's why you saw a little probably change in the early aftermath, right? It was just the publicity around the fact that this was happening. Where I think it's going to be interesting is, to your point, down the road. There's a step in the right direction. And today, there's not a clear other model or other way to think about paying real estate agents. Will someone come up with one? what will we see? Will people be more amenable to that now, understanding how these transactions are funded? Maybe, right? Maybe not. But also I think the answer is it's possible. And so I'm happy with that. I also just you don't want a non-transparent market. I think that even just if we keep it the same and people are more aware of how this is being funded, it is a good thing. And again, so if nothing else, I think I am pro that. And then I do think it opens up the door for new ways to have these things be paid for. And we'll see. And so maybe someone will come up with a good one, and we'll all be happier for it. And if not, maybe this was the right way. And the NAR somehow figured out the best possible way and then forced us all to do it. But only time will tell, I suppose.
At all here.
I did not say that tongue in cheek at all.
Yeah. I think this was the right outcome for this trial. I think that some of the terms in the settlement could have been different, could have been more explicit about the industry rule changes, but it opened up some space for changes in the future. And it also, I guess, look, it gives realtors and agents time to adjust and make changes. And they provide a ton of value. Go out, keep proving the value you provide. And transparent pricing, I don't think is going to hurt you at the end of the day. I really don't.
I don't think so either. Quinn, in closing, I think we obviously both agree on transparency and the importance of that in the market. My hope is that it allows people to negotiate a little bit more. I know that at the top end of the market, from watching way too much Selling Sunset and $1 Million Listing, that there already is some pretty serious negotiation if you're selling a $50 million house. Those agents do not just cleanly go in and say 3%, please. Everyone understands that there's a huge number coming off the top here, and no one, and those buyers are quote unquote sophisticated enough that they're wait, I'm going to know where my $1.5 million is going, on each side of the equation. So I hope that this actually allows for people at, again, the $250,000, the $500,000 range to at least have that discussion. Do you agree with me?
Yeah, I hope so, right? I don't think it totally solves the leverage problem, where part of the reason they have so much negotiating power is because they're talking about a $1.5 million commission. And so we're not fundamentally solving that issue in terms of the negotiating power between the seller and the broker. But hopefully, to your point, it starts to look more and more like that. And people have more awareness about these things can be negotiated. Maybe they should be negotiated. Maybe there's another agent out there who's willing to work with them, who they think is equally good on price. And I don't know the industry well enough to I think make any recommendation on this front. What I can say is I hope it starts to look a little bit more like that, where this feels like a win for everybody in the interaction.
So, I don't know, I guess to close, Quinn, this has been a fun one for me. I think that buying houses is a dream for so many people. I actually love real estate. I've gone through this process a few times of buying a house. And, personally, anything that makes it a little better, I'm in for. But certainly was legally curious as to why this case happened and what were the outcomes of it.
Yeah, before we looked into this case, I wasn't appreciating. I was familiar with the 6%, standard kind of commission, and I saw that there were changes coming as a result of this case. I didn't fully understand the mechanics of it, and it's if you're a first-time home buyer, you don't have a clue how this stuff works. Just knowing how it works is part of your leverage. Never mind being able to sell a $1.5 million, give a $1.5 million commission to the broker. Knowing how it works is part of your leverage. You can have these conversations in a way that's that's more productive. And yeah, I mean, I had fun having this conversation, Alex.
Agreed. Well, whenever we buy the Legally Curious HQ, we're going to be better buyers because of this.
Yeah, that's right, man. All right.
Absolutely.
Have a good day.
All right. See ya. Bye.
Later, Al.
If your rights have been violated, give Mayberry Law a call at 310-776-3764. It's free, and we would love to discuss what you can do. This podcast is for informational purposes only and does not constitute legal advice or create an attorney-client relationship. For specific legal guidance, consult a qualified attorney.